Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Today we're talking about independent contractors and unemployment compensation laws. The Pennsylvania Commonwealth Court, in a recent Villager Realty of Bloomsburg v. Petitioner decision, awarded unemployment compensation benefits to a real estate agent despite the fact that she and her employer, Villager Realty of Bloomsburg, characterized her employment as an independent contractor. Here are the relevant facts. In October 2016, while still working with her employer, Geisinger Health System, the petitioner, claimant, the woman who wanted UC benefits, entered into an independent contractor agreement with Villager Realty to perform services as a real estate salesperson. She considered herself, and so did Villager, an independent contractor. They wrote it right into the agreement. Now, after her employment with Geisinger ended, where she was a full-time employee, no question she was an employee with Geisinger, she continued to work for Villager Realty. Now, her compensation with Villager Realty was 100% commission, no taxes were withheld, and she received a 1099 tax form at the end of the year, thus showing that she's an independent contractor, right? Well, following her separation of employment from Geisinger, and while she continued to work as an independent contractor for Villager Realty, she applied for UC benefits. Not Geisinger, but Villager objected to her claim for UC benefits on the grounds that she was an independent contractor and thus should be disqualified from receiving UC benefits. Under unemployment comp UC law, an independent contractor is considered self-employed, and self-employed individuals are not eligible to receive UC benefits. But, as I said earlier, she was ultimately awarded benefits. The referee in the case noted that for purposes of UC eligibility, the existence of an independent contractor relationship is not established by the way the parties view themselves, but instead how they are viewed as a matter of law. The referee also observed that the existence of a signed contract establishing an independent contractor relationship is not dispositive, meaning it doesn't ultimately decide the case as a matter of law, and that the putative employer bears the burden of proving that the claimant was an independent contractor. And workers and employers often try to characterize their relationship as an independent contractor relationship, despite the facts of the relationship leaning toward employer-employee. And keep in mind, it doesn't matter how you and the employer or the business view your relationship. You can call it independent contractor, you can write it in big red pen on the contract, but the federal and state government entities and agencies, they're going to look at the facts of your case, the facts of your relationship, and they'll make their own determination. They'll reach their own conclusion as to whether you're an employee or an independent contractor. The UC referee in the case applied the independent contractor test to the case. Prong 2 of the test states, with regard to such services, the individual is customarily engaged in an independently established trade, occupation, profession, or business. So was she? Was the real estate salesperson in this case working for Villager Realty of, Bloomsburg? Was she independently engaged in an independently established trade, occupation, or business? The UC referee and later the Commonwealth Court said, no, she wasn't. That's because under Pennsylvania law, she was required to maintain her real estate license with only one real estate broker and be under the same real estate brokers and be under one real estate broker's supervision. So she was only allowed to list properties with Villager Realty and could not list properties with any other real estate brokers according to Pennsylvania real estate law. As such, she could only work for one broker. So if she could only work for one broker, she was not customarily engaged in an independent trade, business, or occupation, despite the fact that that's how she and the Villager described their relationship. So The referee in the Commonwealth Court determined she was not an independent contractor, despite the written agreement labeling her as one, and as such, she was not disqualified from receiving UC benefits. Thus, she was awarded the UC benefits. Now, this does not mean that she is an employee of Villager Realty. Courts said she's not an independent contractor with Villager Realty, but they didn't go as far to say she is an employee of Villager Realty. In any event, as I say, this does not mean that she's an employee of Villager, and as such, if she were, then Villager would be responsible for part of her UC benefits. But that doesn't appear to be the case. So it looks like Villager is going to be off the hook and is not going to be responsible for paying any part of her UC benefits. In fact, the Commonwealth Court stated, however, we diverge from the board's and the referee's analyses to the extent they suggested the claimant was an employee of Villager Realty, because that issue was not properly before them. Therefore, to clarify, we note that the board, the UC board, and the referee did not hold that the claimant was an employee of Villager Realty. The Commonwealth Court also included a footnote which stated, we observe that in cases where a claimant's separating employer is a real estate company and the claimant is paid solely by way of commission, then the claimant is financially ineligible for benefits. So the Commonwealth Court is suggesting that had this woman been separated from Villager, the real estate company in which she was paid full commission, instead of Geisinger, in which she was paid a salary, then the court may have made the opposite conclusion and denied her benefits. So as you can see, this is a tricky area of the law. Employers and workers should be aware that just because you characterize your relationship as an independent contractor does not make it so. Government agencies and courts will use their own tests to determine whether an independent contractor relationship occurs or not. And that could lead to results that neither party intended when they entered into the IC agreement in the first place. Well, that's about all the time we have today for the Scaringi Law Lunch Break. If you have any questions about employment law, UC benefits, independent contractor law, give us a call here at 717-657-7770. I hope you learned a little bit about the law today. Thanks for listening and enjoy your lunch.